Welcome to Short Circuit, your podcast on the Federal Courts of Appeals. I'm your special host today, Ben Field, an attorney at the Institute for Justice, and this is a special live edition at the Hogan Lovells law firm in downtown Washington, D.C. So I'd like to start by just thanking Hogan for their hospitality in having us here. I think that it's now becoming sort of a thing that every good law firm has to have, which is hosting a podcast for their summer associates, and we're glad to be able to provide that here. And this is a real treat for me because I'm going to be on a panel here talking about 3 cases from the Courts of Appeals with my former and current colleagues, because I was an associate at Hogan Lovells for about 2.5 years before coming to IJ, and so I'm excited to be back. Our 3 panelists who are going to talk about cases today are first my current colleague, Kirby Thomas West, who actually has an office directly next to mine at IJ at our headquarters in Arlington. And she's going to be talking about a thorny First Amendment issue for public school teachers. We also have Sean Murata, who's a partner at Hogan Lovells in the appellate group. He's also a Twitter law maven and a repeat guest on the Short Circuit podcast. So we look forward to having him back to talk about maritime shipping and the kerfuffles that can arise from that. And finally is a Hogan associate in the appellate group and another former colleague of mine, Danielle DeSaulnier-Stempel, who's going to be talking about guns in standing. But before jumping into those exciting cases, I just wanted to give Sean and Danielle a chance to talk about, what is Hogan like? What is it like being in the appellate group here? We're happy to be here, and we love to hear about what happens in these hallowed halls.
Well, we're really excited to have you back, Ben. As I mentioned before we started taping, if you just want to jump in and bang out some briefs while you're here, we'd love to have you back. But we're really, really excited to have Short Circuit with us and IJ, who have both been someone that we've supported, I know, through our amicus practice and others, through some of the great work you've been doing in the 1983 civil rights space. As I mentioned also, one of my greatest regrets as an attorney is that I once had to file a brief in opposition against the New Orleans tour guide licensing regime that IJ challenged and that we defended. But although we succeeded in that particular challenge, it was still really great work that IJ does in both occupational licensing, forfeiture, and civil rights that is really, I think, can draw people together across the spectrum. Also really excited to have our summer associates with us today who have been doing a lot of really interesting and great work. Shout out in particular to my team that will be helping a different libertarian organization, the Cato Institute, file an amicus brief in support of a Section 1983 plaintiff in the Supreme Court this coming Monday, which has been a really fun opportunity for them to get to see a brief from, honestly, the very beginning of its conception through the outline to the drafting and all the way to the filing, working with your friend and mine, Clark Nelly from the Cato Institute.
And Danielle, what's your practice like? What brought you here?
Oh, what brought me here? I mean, it's been a while now, but if you talk to any Hogan person, I think we will always say the thing that brought us here is the people, and the thing that keeps me here is the people. And it's just been such a wonderful pleasure to work with Sean and you for a brief stint while we overlapped, and everyone else in our group and more broadly at the firm. I think our firm is just a really wonderful place to be a lawyer and to learn the practice of law. And I'm excited to be joining you on the panel here today.
Great. And speaking of people and people who like to make silencers at home, why don't we talk about this Fifth Circuit case that you're bringing to us today?
Sure. So I'm going to talk about Paxton versus Dettelbach, a Fifth Circuit decision that they issued last month. And as Ben previewed, it is a case about silencers and standing, although it is really a lot more about standing than it is about silencers. The facts are actually comparatively simple, at least as compared to the 3 cases you're going to hear today. There's a federal law that has long regulated silencers by requiring individuals who wish to make one for personal, non-commercial use to pay a tax, file a written application, and if the application is approved, register the silencer. In 2021, Texas decided it did not like that law, and so it passed its own, designed to wholly displace the federal regime. The law said a silencer that is manufactured in Texas and remains in Texas is not subject to federal law or regulation. Individual plaintiffs and the state of Texas sued, seeking an injunction to stop the federal law from applying to silencers that were made in Texas. So that's the background. But like I said, this case is really much more about standing than it is about silencers. The district court found the individual plaintiffs and the state lacked standing, and here is the part that may surprise you, the Fifth Circuit affirmed. So just a couple of preliminaries here to sort of set the table in terms of the standards for standing that we're working with. This is really about the injury in fact requirement, which means you need an injury that's concrete, particularized, and actual or imminent rather than hypothetical. The case came before the court on a motion for summary judgment, so the requirements were more rigorous than if it was at an earlier stage in the proceedings. Two further wrinkles. The first is that this case involved a pre-enforcement challenge, meaning the individual plaintiffs were challenging the federal law before it had been applied to them, and they were also seeking an injunction. And all of that combined generally raises the standing bar. So to kind of distill it all, the plaintiffs had to show a serious intention to engage in conduct prescribed by federal law and a credible threat of prosecution in order to have standing. The panel was 3 conservative appointees, and they unanimously held that both the individual plaintiffs and the states lacked standing. So for the individual plaintiffs, I know those longtime listeners to the podcast are probably familiar with this, but since we have the Summers in the room, typically you would write a declaration, working with the plaintiff and the lawyer, explaining how the law applies to you, how you're going to be hurt by this law in order to show why you would have standing. And I think it's worth quoting verbatim what the individual plaintiff's declaration said here. Quote, "I intend to personally manufacture a silencer for my own non-commercial personal use. The silencer will be manufactured in my home from basic materials without the inclusion of any part imported from another state, other than a generic and insignificant part, such as a spring, screw, nut, or pin." That might leave you with a couple of questions, like, what kind of silencer are you planning to make? When are you planning to make that silencer? Are you planning to comply with the federal requirements to apply for permission to make the silencer, to register it, to pay the tax? They said absolutely nothing about any of that, and that is the fundamental basis on which the Fifth Circuit held that they lacked standing. The Fifth Circuit gave 2 primary reasons for its conclusion as to the individuals. The first was that they never said they intended to do anything illegal. Federal law only prohibits making a silencer if you don't comply with the requirements, and the plaintiffs never said they were going to forego those actions or that they were unable to do them, like if they didn't have enough money to pay the tax or they were statutorily prevented from satisfying any of the filing requirements. And the court distinguished between a case like this and cases where you have a blanket prohibition, which is comparatively common in the gun context. So a law saying no one under the age of 21 can carry a firearm, full stop. You don't have to do anything in advance to trigger the law. It just applies to you as long as you have a firearm. And the second basis the court gave was that the individuals didn't give enough detail to show a serious intent to make a silencer such that any injury was imminent. And again, it looked at other Second Amendment cases, including one where the plaintiff talked in detail about the type of gun he wanted to buy, the dealer he planned to buy it from, and the price. Basically, in those cases, the gist is that if not for this law, I would go buy this gun today. And that was missing here. There was nothing sufficiently detailed about their imminent intent to make these silencers. So that was the individuals. But this case had a second plaintiff, which was the state of Texas. Interestingly, the law here actually required Texas to file a complaint seeking to uphold the Texas law, asking for what's called a declaratory judgment, so declaring the Texas law is constitutional and legal if any plaintiff petitioned the state and asked them to do it, which is how the state of Texas got involved here. And I think you can actually tell from the briefs in the Fifth Circuit that Texas didn't really think this case was all that worth litigating because it devoted only like 3 pages to Texas's own standing arguments. But they were here and they had to make them. So they put forth 2 bases on which Texas supposedly had standing. I'm going to just pause and say a couple words again because we have the Summers in the room about something called the Mellon Bar, which might not be familiar to everyone. So the Mellon Bar is a doctrine that says states can't bring what's called a parens patriae suit against the federal government. The idea is that when you bring a parens patriae suit, you're suing on behalf of the citizens that you represent to protect their interests. But when you're suing the federal government is supposed to be representing those same citizen interests, so the state can't really step into its shoes. There are some ways that you can get around this bar, however, by asserting what are called quasi-sovereign and sovereign interests. So Texas invoked both theories. It said it had a quasi-sovereign interest in its citizens' health and well-being and a sovereign interest in the power to create and enforce its own legal code, but the Fifth Circuit rejected both. These are both recognized ways to get around Mellon, but Texas just hadn't done enough to show they applied here. It didn't have any unique quasi-sovereign interests that the plaintiffs themselves couldn't assert, which is a requirement here. Otherwise, Texas is just sort of volunteering as tribute, to use a popular phrase from the Hunger Games, to litigate those claims on its citizens' behalf. And second, although there is a sovereign interest in enforcing your own legal code, the mere desire to immunize state citizens from federal law doesn't cut it. You have to actually set up a legal code, set up a program, administer that program, do something more than say, hey, we don't like that federal law, so it's not going to apply in Texas. So that is Paxton versus Dettelbach. The plaintiffs have until early August to petition for a rehearing en banc, so it's possible this case isn't done, although if the attention given to these issues in the briefs is any indication, I think that petition is probably not forthcoming. But, just a couple of thoughts about some broader trends that I think this case exemplifies. Longtime listeners and recent Supreme Court watchers will probably know that the Fifth Circuit has not been doing so well, particularly on standing issues in the Supreme Court recently. I counted them up, and I got 9 Fifth Circuit cases on review this term, 6 of which were reversed by the Supreme Court, and 5 of those 6 reversals were either unanimous or 8-1 votes, all written by conservative members of the court, Justices Thomas, Kavanaugh, Roberts, and Barrett. In the Alliance for Hippocratic Medicine case, the mifepristone case, it was a 9-0 reversal, and they explicitly called out what the Supreme Court referred to as the Fifth Circuit's unprecedented and limitless approach to standing. Same in Murphy, finding no standing to challenge government interactions with social media. Justice Barrett called the Fifth Circuit's doctrine startlingly broad and boundless. We also have some previous cases from earlier terms, again, striking down Fifth Circuit standing decisions as making an uncharted path or entirely novel. So, for example, U.S. versus Texas, California versus Texas, Doe versus Brown, which was the student loan borrowers case, and then Holland versus Burkine, which was a case about Texas's standing to sue under this quasi-sovereign and sovereign interest doctrine. So maybe one takeaway from this case is the Fifth Circuit is getting the message. Remains to be seen. The facts here, I think, were very different from those cases, and particularly since it didn't seem like the state believed too strongly in its interests, maybe the Fifth Circuit just kind of took that as an out. I also think there's a very interesting footnote in this that flags an argument Texas was making about the Mellon bar. So Texas argued that the Mellon bar shouldn't apply at all when you're dealing with quasi-sovereign interests, and the Fifth Circuit flagged, we're not going to answer that question because they haven't asserted an adequate quasi-sovereign interest, but this is definitely an area that I expect we'll see continued litigation on, and it's something that courts and commentators have already been talking about for a while, particularly as we've seen so many more suits from states challenging the federal government in recent years.
So we at IJ obviously our bread and butter is bringing constitutional claims against the state or federal governments. And so, the first step is always drafting a complaint or declarations for an injunction. And I don't think I've ever sent one to our director of litigation, Dana Berliner, where the comment did not come back. You need more details on precisely how you've been injured. So I'm curious, Kirby, did this case strike a chord for you?
It definitely did, yes. Danielle, you were talking about the mifepristone case, and one of my last appearances on Short Circuit was when the Fifth Circuit had just decided the mifepristone case, and we were contrasting that with a case out of the Fourth Circuit in which the Fourth Circuit held that parents who were challenging a Maryland school's policy on not notifying parents if children were socially transitioning in schools using different pronouns and different names, that those parents didn't have standing, and the parents said, well, the whole point of the policy is that we don't know if we're affected, but we have children in the school. And the Fourth Circuit there said the parents didn't have standing. And then the Fifth Circuit had just said that these doctors did have standing in this kind of more outrageous situation, the mifepristone case. And I think whenever these standing issues comes up, as Ben said, it does strike a chord because courts can be really all over the place. And I think I'm interested, as Danielle said, to see if the Supreme Court's kind of recent cases on this will provide a little bit more consistency in the lower courts. But I think still generally, frustratingly for public interest lawyers, what happens is if a court does not want to decide a case, they can find a way to use standing to kick you out, which is why Dana Berliner is quite right to say, add more detail. And we need to be careful about how we draft our complaints.
And I think this case also is a good example of how much the states are really taking a lead in a lot of what used to be public interest litigation. I mean, it used to be, back in the day, I'm old enough to remember where you had to troll and find some person who was actually affected by it. And sure, maybe they were being supported by groups that had sort of a broader ideological interest, but you actually had to go find people. But now it seems like, and this is honestly true of both red and blue states, that when you have, a Democratic administration, you have a wave of red states and elected attorney generals who want to make a name by suing the federal government. And when you have a Republican administration, you have a group of blue states that go and sue the federal government to try to make a name for themselves. And it's really a change as to how much we've seen sort of state standing being the question, because the states are the ones who are taking the lead in these big cases, either to get favorable venues or honestly just because they think it's good publicity for their attorneys generals. It's a way different than even it was, 10, 20 years ago.
And so why don't we turn now to a case where standing is not at issue, where indisputably somebody was being made to pay $500 or so that they didn't want to pay. And what happened there, Sean?
Sure. So this is a case out of the D.C. Circuit issued on July 5th, right after the July 4th holiday, called Evergreen Shipping Agency versus Federal Maritime Commission. First of all, at the very beginning, disclaimer, myself and my colleague, Kate Stetson, filed an amicus brief in support of the petitioner in this case. So it is a Hogan case. But I love this case even beyond working on it because it has everything that I love about administrative law and appeals, which is that you learn about the plumbing of parts of the world that you have taken for granted all of your life, and learn that for everything that occurs, there is a group of people intensely focused on this really small thing that you have no idea about. So for instance, you may not have known there's an agency called the Federal Maritime Commission, which among other things, it like many sort of New Deal era type agencies, have a requirement that practices that relate to, again, among other things, shipping containers be, quote, just and reasonable, which is a very broad term. But shipping containers are those things that you see on those giant ocean freighters. They then get transferred to the back of semis and they go to warehouses. And shipping containers literally make the world run, which is something I discovered during all of this. Because think about how stuff gets from, China, Japan, to your doorstep. It's somebody makes it, they put it in a container, they put the container on a ship, the ship comes to a US port, they take it off the ship, they deliver it to a warehouse, they deliver it to a store. And these shipping containers make the whole thing work, because if you don't have shipping containers either to go back to Asia or any place else, you can't ship new things. And if they're sitting on a port somewhere, you can't get the stuff to your house. So, during COVID, when people used to say, oh, we're having supply chain issues, this is the stuff they're talking about. And so a big issue in the freight industry, I came to learn, is something called freight fluidity, which is the question of, is this sort of circular process of getting containers to where they need to be happening? Because if it's not, the whole thing gets snarled. And it's like a traffic jam where once it gets bad, it progressively gets worse. So, and this can happen in two ways. One is that you don't pick up your container in time, and so it's sitting on the port and you can't get new stuff in. Or you keep it for too long and it's not going back to where it should. Waiting too long is called demurrage. Holding it too long is called detention, and they're basically two sides of the same coin. And so one of the ways that the shipping industry tries to incentivize people to return things or pick up things when they're supposed to is you have a contract and it says if you don't pick it up or deliver it by this period, we're going to start charging you. It's essentially a late fee. But it's subject to the Federal Maritime Superintendents to say whether it's just or reasonable. So, I think shippers want to say, look, whatever's in the contract should go. And the people who pick up and drop off these things want more careful superintendence by the agency. And everybody kind of petitioned to say, how about we have some sort of rule that defines what is just and reasonable with respect to these charges? And what the Federal Maritime Commission said was, well, we're not going to set out a hard rule, but we're going to issue an interpretive guidance that says primarily what we're going to focus on is this incentive principle. In other words, is this fee incentivizing you to pick off or drop off on time? And if the fee isn't doing that, it's going to be unjust and reasonable. But in response to comments from everybody who said, wait a second, that shouldn't be the only thing you think about, the Federal Maritime Commission said, but don't worry, we're going to consider all the facts and circumstances in any case. It's one of those multi-factor balance tests where no one factor is controlling. So this brings us to Evergreen Shipping. And as Ben mentioned, it is a case that went all the way to the DC Circuit on $510. But it's obviously the broader principle, because these detainer and demurrage principles are hundreds of millions of dollars to the shipping industry. And more importantly, they are how you get the freight going, because they don't really want your late fee. What they want is they want you to pick up and drop off on time. So what happened in this case was typical COVID situation. They couldn't get the container out of the warehouse and back to the Port of Savannah where it's supposed to. They ran out of what's called free time, which is essentially your grace period to return it. But they couldn't return it to Savannah when they wanted to because the Port of Savannah was closed for the Memorial Day holiday. So the holder of the container said, well, gosh, the incentive principle doesn't apply because we couldn't return it. The port was closed. And our response was, the Evergreen's response was, but you could have dropped it off sooner when you were supposed to, and you knew about this closure way in advance. Memorial Day is the same time every year, and you knew the port was going to be closed. And the Federal Maritime Commission said, well, under our incentive principle, it's not incentivizing, therefore the fees are unreasonable. And Evergreen took a petition for review to the DC Circuit. And it's a great, breezy 10-page opinion. I really recommend it. It also sort of covers a lot of the Administrative Procedure Act basics of how agencies have to go about carrying out their duties. Because first of all, the DC Circuit said, wait, you promised one thing and then you said another. When you passed this interpretive rule, you said you were going to consider all the facts and circumstances. But when it actually came time to apply this in practice, all you looked at was this incentive principle, which is the very thing you said you weren't going to do, agency. You need to look at all the circumstances, including the fact that they already had free time with this, that you knew about the closure in advance, all of these other factors that you never considered. And moreover, by the way, when you did discuss some factors, you didn't really explain what you were doing. So, the essence of agency action, I always say, is it's not a question of, are you right? It's, did you do your homework? Did you check the boxes? Did you do the things you said you were going to do? And I think actually this carries across to what Ben was saying about the declarations is, agencies should always say a little bit more. Like, okay, you have a conclusion? Well, why? Well, why? And then if somebody has an obvious response to that, well, why don't you agree with it? And so, the two takeaways I think for agencies are, one, don't pull bait and switches. Don't say you're going to do one thing and do another. And second, always make sure if you're going to have a totality of the circumstances, actually consider the totality of the circumstances and march through each factor. But I think the broader implication is that it's going to be easier for shipping companies to justify these charges, which should then hopefully make it easier for products to get to your door.
So one thing that was, I had never heard of the Federal Maritime Commission before reading this case. And, in most of the economy, you make agreements with people, you write a contract and you honor the contract. And there's no federal bureaucrat looking over your shoulder to decide whether it was a good contract. And this one also seemed weird because the commission itself seemed to be inviting briefing on the specific question of how to apply this incentive rule. And so I was just wondering, since you were representing, the industry at large, I'm curious, what's really going on behind this? Why is there this fight over $500 in this agency that seems to be nitpicking the industry?
Yeah, so this is, I think, really a test case because, the commission actually did invite amicus briefs. And the way it's typically handled is there's a small claims hearing officer that would resolve these things, and their decisions are often final. But the commission, as they have the right to, kind of took on this case to try to state some broad principles. But unfortunately, the broad principle they decided to state was the incentive rule controls overall, even though, again, they had promised that they weren't going to do that. And I think the broader, sort of push-pull is between people who take containers who, would like to not pay as much money, and the industry, which, again, I represent the industry, so that I get to characterize this, is they want to try to keep their freight flowing as freely as possible. And really what they want is they want their contracts to control to a large extent. The idea is, even if when the Federal Maritime Commission was created, this was a large, the shippers were kind of monopolies and they can impose terms, now there's a lot of competition in the industry. If you don't like us, ship with somebody else. And there actually terms do vary between contracts on how much free time you get or how much the detainage or demurrage fee is. There's a lot of competition. So I think a lot of their argument is, look, we can let the market solve this. That's the libertarian plug.
I agree, Ben. As someone who is not familiar with this and also learned about the Maritime Commission for the first time reading this case, it did seem like one of the other factors that hadn't been really at all addressed by the agency below was the fact that this was contracted for, and that these very sophisticated parties had agreed that this was what the conditions that they wanted to be there. But I also agree with you, Sean, that it was just such an interesting peek into this world that I was blissfully unaware of how my Amazon package gets to me. So I did enjoy. I also recommend this to everybody's reading.
I completely agree with all of that. And just one other thing that I thought was really interesting about this case, which Sean mentioned but might have gotten sort of lost in all of the many other interesting points about it, is that no one appealed the original decision. The commission decided sua sponte to take this question up and to just sort of articulate this rule. And so much of the time, I think we see these insufficient agency decisions from agencies that just don't want the case there in the first place. They're like, really? Come on, guys. Fine. Okay. We'll just get rid of it in a paragraph or two. But that was not this. They chose to take this case. They chose to answer this question. So great illustration of the principle, be careful what you wish for, be careful what you do when you're an agency. And if you're going to take that case, you should definitely be offering some reasoning there.
So we've talked about the grand federal regulation of maritime shipping. We've talked about a state fighting the feds over control of gun legislation in that state. But on the theory that all politics is local, we're going to take it to a little bit more of a mundane but still very important dispute over one teacher getting fired in Massachusetts. So Kirby, why don't you take us away on that one?
Happily. So I am going to talk about a case out of the First Circuit called McCrae versus Matos. This is a case, as Ben mentioned, of a teacher in Massachusetts. She is also active on TikTok. So she's a grandmother who is active on TikTok and had posted 6 different TikTok posts, which I would describe as Facebook memes. So they are the kind of thing that my late grandmother, who was very sweet and very conservative, but also surprisingly spicy on social media, might have posted. So they're a little bit crass, a little bit crude, but not outside of the mainstream of kind of conservative thought, I would say. She had posted these 6 kind of controversial TikTok posts under the name Nana Mac of 4. The TikTok account did not include her real name. After posting these TikTok memes, she was elected to the Bourne School Committee in Massachusetts. Later, she was then hired in a different town about an hour away, Hanover, Massachusetts, as a business and math teacher. Shortly after she was hired in Hanover, back in Bourne, where she was on the school committee, someone brought the school committee, made the school committee aware of these controversial TikTok posts, and it became a little bit of a hullabaloo there. They scheduled a meeting to discuss it. A local paper ran a story about her posts on TikTok, and there was, a number of complaints. After this, the drama made its way to Hanover, where she then had started her job in the school year. She was hired in August, and in September had started her job as a high school teacher. And she was ultimately fired expressly because of the TikTok posts. In the district court granted summary judgment for the defendants that she, applying a framework from a case called Garcetti versus Ceballos, which is about First Amendment retaliation in the context of government employees. So when can the federal government, or not the federal government, when can any government fire an employee, and what kind of considerations do you have to take about speech? Is it part of their job as an employee, or is it the kind of speech that they were just making as a citizen outside of their job? And the main question on appeal was the district court right to apply that Garcetti framework, or was this more like other kinds of First Amendment retaliation cases. So typically in a First Amendment retaliation case, what you have to show is, 1, you engaged in speech protected by the First Amendment. 2, there was some adverse action taken against you by the government, and that action would have deterred a person of ordinary firmness from continuing to engage in protected speech. And then 3rd, that there's direct causation between the adverse action and the speech that you made. And what Ms. McRae argued is this should be just a normal First Amendment retaliation case. This was speech I made before I got my job. This wasn't the kind of thing like in Garcetti where the speech was made as a part of the person exercising their job duties, and it really makes sense where, okay, I'm treating you as employer-employee, and how this is relates to how you are actually performing your job, and we can take employment action against you because just because your speech is, or part of your job is speech, doesn't mean that we can't, fire you for it if it's part of how you're exercising your job. The First Circuit said no, she was wrong, and that in an opinion that I'm interested to hear the rest of the panel's thoughts on. It's a little more flip in style than I like in a legal opinion. The judge refers to this as a squabble and kind of editorializes that she didn't take her termination on the chin, and just some kind of a style that doesn't resonate with me. But the First Circuit said the Garcetti framework was the right framework to apply. And there, what you are looking at is, did the employee speak as a citizen on a matter of public concern? Second, did the government entity have adequate justification for treating the employee differently than member of the public? And third, was the speech a motivating factor in the adverse employment decision? Now here, for the first and third factors, clearly this was, she was speaking as a citizen on a matter of public concern because she wasn't even an employee yet. So this wasn't part of her job in any way. And then was the speech a motivating factor? The school said, we are firing you because of your TikTok posts. So the question really was kind of more of a balancing between, did the government have a sufficient interest? Did the school have a sufficient interest in minimizing disruption to take this adverse action based on her speech? And the First Circuit said yes, they did. That there was a concern that she was going to make the school a unsafe environment for LGBT students or minority students, and that this was a sufficient reason for the school to take this action of terminating her employment. And as I've probably kind of revealed from my recounting of the case, I think this is pretty problematic. I'm speaking to a lot of Gen Zers who know that, your public life or your social media life starts very, very early now. And I don't think the court kind of briefly touched on this, but I don't think there's a way to draw a principled line for at what point is it too far back to look that you're going to be disqualified from government employment for potentially your whole life because of something that you said unwisely on social media. And, although this was someone who was, older and a grandmother, and I think, probably it was an error of judgment for her to be making these kind of posts, I don't see a principled way to distinguish that from a situation where somebody, who's a college student and says some things that are incendiary, then that can create employment problems for them in the future. I see that as pretty problematic.
And Danielle, I know that we were talking before we started recording that the style of the opinion also struck you.
Yeah, it did. The flip nature that Kirby mentioned struck me, but I will confess the thing that stuck out most was actually the headings in the brief. They are table setting, the fallout, the main course, just really not the sort of thing you normally see in a judicial opinion. And we were chatting, do we think this is something the clerk wrote in? But it seems perhaps this is maybe just this judge's style. I will confess it's a little bit off-putting to me as well. I think there's a fine line between this kind of cleverness in opinions that we've been seeing more of and opinions that are not taking seriously the very personal interests at issue. Whether you agree with what she said or not, she is entitled to have her day in court. And something that, when I was clerking was really drilled into me by my judges is that we need to be very respectful of that. And so, however it was written, whatever the editing process was, I agree that it just sort of didn't sit quite right with me. And, something else that jumped out at me about this opinion, Kirby, is that they went out of their way to rationalize the idea that like we're looking to her pre-employment posts. That's okay under Garcetti. We have all of these reasons. And then they had this separate point where they said, well, and it's actually fine because she sort of made the statements again once she was employed. And the rationale they gave for that was that at this school board meeting, the statements came up, they were talking about it, and Ms. McRae said, I apologize for the statements, or I apologize for how they came across. But she didn't actually disclaim the statements. And the court looked at that and said, well, she's not disclaiming them. So she's basically reaffirming them and making these statements again once she's a government employee. And that seems like another concerning part of the test that they're applying here.
I am so glad you raised that. That really stood out to me as well. And it seems like you could have a situation where your boss calls you in basically and says, hey, I see these social media posts you made a couple years ago, and I think they're kind of problematic. Do you still think those things? And you say yes. And then essentially that's like you making all of that speech on the job, which just seems crazy to me. I'm glad you raised that.
And Sean, you're a frequent participant in the social media space, and I follow you on Twitter, and I don't think I've ever seen anything that has offended me or wanted me to disrupt the school environment, but I'm curious if you had any thoughts arising out of your own experience.
I think what's ironic about the tone that we've been talking about in judicial opinions is that I think some of it is driven by social media, which is that if you have an opinion that's a zinger, or at least in your own mind, it gets shared, and people who are in the know, say you're really clever. And, like I think any sort of writer who takes pride, you want people to say, hey, this is cool. And so something that sort of gets you noticed is to use these kinds of tricks. And I think there's a couple problems. One, the number of judges as true of people who think they're funny is probably far greater than the number of people who are actually funny. And it's even harder in the judicial context where we are basically on pain of contempt forced to laugh at your jokes, whether they're funny or not. And so I think there can be a little bit of an echo chamber of if you're only surrounded by people who are sort of told to tell you or make you believe that you're funny, you believe that you are. And second, there is, of course, a push towards accessible writing, but I think there is a difference between clear writing and flip writing. You have people like Judge Sutton who are maybe not, the funniest in their opinions, but are remarkably clear and use plain language, and you can understand what they're saying. And then there are sort of the writers who I think they're the next Elena Kagan, who is actually quite funny and also a very good writer, and who can do that. But it's also one of those things where it's a really high degree of difficulty, and unless you're certain that you can land it, you really shouldn't try. And there are some great examples of funny zingers in opinions. The classic example is John Roberts had an opinion at the Supreme Court, which was about whether AT&T can have personal privacy, and the court unanimously held it didn't. And his last line was, we trust that AT&T will not take it personally. And it's not only funny, but it's good because, one, it has something to do with the case. It makes the point he was trying to say, which is that, AT&T is not the kind of thing that has personal anything. And second, you're not punching down. AT&T will not have its feelings hurt by you making fun of it the same way it would be, an individual who lost her job. So you just really have to think hard before you deploy these kinds of rhetoric.
I think Sean is right that the court was definitely writing here for a broader audience in a way that hampered the opinion. But the place where you can best see it is actually a place where I agreed with the court on the substance, though not the tone, which is a footnote in which the court describes qualified immunity as follows. For those new to all this legal mumbo jumbo, qualified immunity is a judge-created doctrine which lets public officials off the hook for money damages when they decide open legal questions in reasonable but ultimately wrong ways. Which, yeah, that's right. But again, the fact that it starts with, for those new to all this legal mumbo jumbo, I think is a clue that the audience that the court was writing here for was perhaps not the parties and lawyers who are going to be referencing this case later.
And Sean, I'm also glad you brought up Judge Sutton, because another thing I like about his writing style is that he very often acknowledges when things are difficult and that it's not always easy. And I think in a case like this, it is a tricky issue, because if you're running, a government institution like a school, Both of the jurisdictions at issue here are more affluent, very progressive areas in Massachusetts, one right across the bridge in Cape Cod, the other on the North Shore. And so I could definitely see, if this teacher comes in and she said controversial things about LGBT, trans issues, and immigration and race, that it could cause a problem. But on the other hand, obviously, if she were saying that in a different place, or if she had viewpoints that were more congenial to the people that she was, living near, then it would be less of an issue. And so there is implicitly a sort of a heckler's veto or viewpoint discrimination going on here. And I think that when you then have a judge writing an opinion that's kind of dismissive towards the plaintiff, she's compounding that viewpoint discrimination that's going on because she clearly also doesn't, share the views of the plaintiff in this case. And I think that it would be not just a better opinion that was more respectful, but I think that it would be more in line with the First Amendment to acknowledge this is a tricky issue where we've got government employment on the one hand, but also free speech on the other, and to take a respectful tone that doesn't compound the First Amendment violation, I think would have been the preferable way to go about it. Well, thank you all so much for taking the time to chat with us about these cases. Thank you again to Hogan Lovells for hosting us. And on behalf of my colleague Anthony Sanders, our regular host, I'll conclude just by encouraging all of you to get engaged. So thank you to everybody for coming. So for those on this half of the room, who I guess are the summer associates here.
It's like bride side, groom side.